Welcome to the Workers' Compensation Board's webinar on the Bill 30 legislative changes that impact the workers' compensation system. Bill 30 is bringing about numerous enhancements to the workers' compensation system. This webinar will provide you with an overview of the legislative changes, highlight your responsibilities, and provide you with the resources to help keep you informed throughout these changes. Employment health benefits and obligation to reinstate are being provided in their own webinars. They will not be discussed in detail in this one. Numerous legislative changes are occurring over the course of 2018. We will touch on all of these changes throughout this webinar. 4 of these changes were open for consultation from January 2nd to March 6th. These included developing a code of rights and conduct, amending the process for estimating earnings capacity, providing interim relief during a review or appeal, and establishing an employer's obligation to reinstate injured workers. The following changes are effective for claims occurring on or after January 1, 2018. Retirement benefits have been enhanced to help workers who were unable to contribute to a pension plan because of their reduced earnings while they were on wage loss benefits. Normal retirement age has been extended to 65 or 5 years following the date of accident, whichever is later. There is a new lump sum fatality benefit of up to $90,772.20 provided to the spouse, dependents, or the estate of a worker who died as a result of a workplace injury or illness. Additional changes that were part of the January 1st legislation include WCB now provides an updated cost of living adjustment calculation based on 100% of the changes in the Alberta Consumer Price Index for eligible workers. In other words, the previous 0.5% reduction has been removed. This applies to anyone who is eligible for the COLA adjustment on or after January 1st, 2018. Safety associations funded through WCB collected levies receive their grant installments from WCB only after satisfying oversight requirements established and delivered by Occupational Health and Safety. Legislation now includes a regular review schedule for the workers' compensation system. Our next review will be in 3 years, and then reviews will happen every 5 years after that. The April 1st legislation included benefit changes around expanding presumptive coverage to additional occupations that have linkages to certain conditions. These include expanded presumption of heart attacks to paramedics, in addition to firefighters. If they have a heart attack within 24 hours of being dispatched or attending at an emergency response, the heart attack will be presumed to have arisen and occurred in the course of employment. There is also expanded presumptive coverage for post-traumatic stress disorder to correctional officers and emergency dispatchers, in addition to first responders. It is important to remember that WCB has always reviewed these claims for acceptance. These legislative changes just involve adding a presumption. Also, for claims occurring on or after April 1st, 2018, WCB has added a presumption for traumatic psychological injuries for all workers. Once again, WCB would always review these claims for acceptance. The new legislation is just adding a presumption. What that means under the new legislation is that if a worker has been exposed to a traumatic event or a series of events during the course of employment and then diagnosed with a psychological injury by a physician or psychologist using the Diagnostic and Statistical Manual criteria, their injury would be presumed to be work-related. Some common diagnoses would be acute reaction to stress, post-traumatic stress disorder, adjustment disorder, or phobias. WCB has defined a traumatic event as a direct personal experience of a work-related event or directly witnessing a work-related event that is reasonably and objectively assessed as specific, sudden, frightening, shocking, and/or involving an actual or threatened death, or serious injury to oneself or others, or a threat to one's physical integrity. Examples include victims of a robbery or hostage-taking incident, witnessing the death or severe injury of a coworker, or providing assistance to victims of severe physical trauma or fatalities. Employers should keep good incident records as a worker might have a delayed reaction to the traumatic event. There have been no changes to the acceptance of chronic psychological injuries, and they will still be reviewed as per our policies. Effective September 1st, 2018, WCB will have a Code of Rights and Conduct that provides articulation of the rights of workers and employers in their interactions with us and how we commit to operate in recognition of these rights. These include: you have the right to be treated with dignity and respect. You have the right to fair and impartial treatment in your interactions with WCB. You have the right to effective communications. You have the right to full and correct information in your interactions with WCB. You have the right to examine all relevant documents when a decision directly affects your interests. You have the right to privacy and confidentiality. In the event of a breach of the code, WCB will either have a meeting with you, provide the relevant information, provide a written summary, or provide a written or a verbal apology. Once in place this December, WCB will consult with the Fair Practices Office regarding our Code of Rights and Conduct. WCB can estimate a worker's impairment of earnings following an injury once a worker has reached a medical and vocational plateau and is unable or unwilling to secure suitable employment, or they fail to maximize their earnings capacity. WCB will ensure all reasonable efforts have been made to help injured workers in their job search. Vocational services have been offered and completed, and a vocational plan has been developed with the worker, and a job search has been completed, or the worker declines to participate in any aspect of the vocational planning and/or job search. This new legislation applies to all claims with the date of accident on or after September 1st, 2018. Historically, maximum insurable earnings has served two purposes: setting an annual maximum that injured workers can receive as wage benefits, compensable earnings, as well as setting a maximum that employers will use per worker when reporting insurable earnings in order to set premiums, assessable earnings. Due to the changes in the maximum compensable earnings, WCB will no longer be using the term maximum insurable earnings interchangeably. The cap for maximum assessable earnings used in determining employer premiums does not change for 2018 and will remain capped at $98,700. In 2019, we will use the same process to establish a cap for maximum assessable earnings, which will be announced around rate setting time. What is changing September 1st is that we'll be removing the cap on maximum compensable earnings. This means workers injured after September 1st will be compensated with 90% of their total net earnings with no limit. The removal of the cap does not apply to personal coverage holders in 2018. Any changes to 2019 are yet to be determined. Benefits will be adjusted for severely injured young workers with injuries on or after September 1st, 2018 to mitigate the hardship they might otherwise experience. This will increase our compensation rate to the Alberta average earnings amount if they earn less, approximately $57,500 in 2018, are under the age of 25, or over 25 and enrolled in an academic vocational program and have experienced a severe injury. The legislative changes are enhancing benefits for all surviving spouses when a fatality occurs on or after September 1st. The 5-year reducing term pension is replaced with a 5-year full pension. This increases benefit security for all spouses and partners and reduces the financial pressure by ensuring they will receive 5 full years of pension before WCB reviews their vocational status and capability to see if they're eligible for additional benefits. The age limit for full benefits being provided has increased from 18 to 25 to allow time for those children to complete post-secondary school. The extension ends when the child reaches 25 or is no longer in school, whichever comes first. Spouses and partners will be eligible for retirement benefits when and if their pension ends. For decisions after September 1st, 2018, the window for appeal to the Appeals Commission has been extended to 2 years from 1 after a decision has been made by the Dispute Resolution and Decision Review Body, DRDRB. Please note that there is still a 1-year time limit to have a decision reviewed by the DRDRB, which is the first level of appeal. After September 1st, interim relief will be available for both workers and employers during a review or appeal. The intent is to provide workers and employers with the added financial help they need during the review or appeal process. Interim relief for workers is provided at a rate based on the lesser of the worker's gross annual earnings or the equivalent of minimum wage for the year, approximately $28,000. Interim relief for employers is provided by suspending invoices pertaining to the disputed amounts. The interim relief will be paid by WCB and can be granted at either DRDRB or the Appeals Commission. Interim relief may be available to a worker if the decision under review or appeal affects their entitlement to current wage loss benefits in the amount of $500 or greater. The worker has an arguable case with supporting evidence that could affect the decision in the case. The worker or spouse is ineligible for any other financial support, and without interim relief, the worker and his or her family would be placed in necessitous circumstances and/or face probable forfeit or seizure of assets. Interim relief may be available to an employer if the decision under review or appeal concerns an amount greater than $500 in premiums. They have an arguable case, as well as demonstrating that the wait time to have the matter resolved will place them in significant financial hardship, such as the inability to continue operations and/or the employer being forced to lay off a significant portion of its workforce. If the worker was not successful in the appeal, then the interim relief will end and WCB will not recover the interim benefit amount that was paid to the worker unless there was deliberate misrepresentation or fraud. This amount will not be charged to the claim and thus will not impact the employer premiums. If the worker was successful, the value of the interim relief will be deducted from the arrears owing to the worker. These costs will be charged to the claim accordingly. For employers, their account will be reconciled based on the final decision. There are additional changes that come into effect on September 1st. To ensure you get all the information you need, we have separate webinars developed specifically on these additional changes, which include continuing coverage for injured workers under their employer's existing health benefit program to prevent disruption to the workers' health coverage, and establishing employers' obligation to return injured workers to work following a workplace injury. We recommend that you review the webinars on these changes as they can directly impact you as an employer. Make sure you know what to expect with these changes so you're not at risk for any penalties. Further changes are being led by the Medical Panel Office, which includes workers being able to select an independent medical exam doctor from a roster effective June 1st. The Ministry of Labour is leading the development of the Fair Practices Office to open Monday, December 3rd, 2018. This office will be independent of WCB and accountable to the Minister of Labour. It will serve an ombudsman-type function for Alberta's workers' compensation system. In addition to fielding, reviewing, and addressing concerns about administrative fairness in the system, the Fair Practices Office will ensure system assurance and effectiveness and issue public reports of its findings. The Office of the Appeals Advisor will move and become part of the newly instated Fair Practices Office later this year. The 2018 updates page on our website is a great resource so you can stay informed about the upcoming changes. You're encouraged to sign up for our new email newsletter that we'll send out to subscribers with important business updates. We'll also continue to update the website as more information is available.